Local Society Ministry. So this is law of contracts. Sorry, law of immovable properties. Law of immovable property in Ghana. Law of immovable property in Ghana. So we start. Now, let's look at the when it comes to properties. Okay, of course, the customary law, the common law, and then the law of equity. They all come to play, and then the statutes. Okay, right. So it's very good we have that. So we should know the various interests. Now,
so let's take a brief look at the definitions. Some definitions I want us to look at, which is very crucial. I'll go to some definitions. For instance, we have ownership. So ownership would be sum of rights, so all the right that you have, and this right includes the use, possess, and then dispose. Okay, so the right to use, the right to possess, the right to dispose, all together will form the ownership. So in totality, everything that you have in association with something either tangible or intangible is the reference for ownership. Now, control, that is to have authority or power over something, that is the control. Now, possession is direct and or indirect control. So direct or indirect authority or power over something, right? And trespass is entry into or interference with. Okay, entry into or interference with. Okay. Then there's another point I want us to look at. The trespass can take two forms. We can have the civil, and then we can have the criminal one. So the civil one was the either by accident or by intent to enter. Okay, intent to enter, either by accident or you did not actually plan to have a particular kind of you don't have the notion to trespass. So far as you are on the land, it amounts to trespass. But the criminal trespass usually would have to involve a greater intent or intent to trespass, the will, and then the mens rea or the actus to commit that particular act of trespass that would elevate it to the level of a criminal trespass. Then the right, when you talk about right, we are talking about all the various interests. Okay, interest. Okay, so right is more or less the umbrella term, and the interests are under this umbrella term, right? So rent, to lease, to freehold, all these are with respect to duration. Of course, freehold forever, lease a specific period of time but long term, and then rent is a contract form, relatively short, right? I'll put it this way, but as we go on, we'll come to understand. There are a few terms that we'll look at. For instance, we have the testator. Testator, let me put it here. That one may appear in what we'll be discussing, so I must put it here. Okay, so we have the testator. I need to put that one here so that we can add it to our discussion. Testator. The other terms we can have we can also have this one. Other terms which may not be related to the offeree, the offeror. These are some of the terms that are used in law. We have so usually we are looking the OR. That's what I want to draw attention to. The OR is the bigger or the leader or the one with the higher authority, and then the EE is the lesser person. Okay, so just that notion let it start coming into your mind when you start talking about law. Right, so we'll take it from where we left off and then see how we can deal with this. So this is the summary of everything under the immovable property, right?
Now, when you talk about the right is a general thing, and then interest is specific. Okay, so you can have the allotted interest. Of course, that is where the people conquer and then take over a particular land. Okay, then you can have the usufructual interest, where you convert a raw place to an economic entity that you can make use of. Okay, and then you can have the customary freehold. So freehold, that is having interest in a particular thing with no limit with respect to time. Okay, so you can look at the various forms of link: possession to use to control, and then interferences in all these levels, so that you can actually talk about the various types of trespass, conversion, detainee, and so on and so forth. So let's move on. We are talking about land, immovable property. Of course, it may have some shackles on it, that is this one. Then we can have those that can be moved from it, and then we have the fixtures. Fixtures are fixed. Okay. Now the first thing I want to actual possession. So if you do something and reduce it to use possession, actually then you are in possession of, you are in physical, you exercise physical control over that thing. Okay, so that's actual possession, right? Now let's look at under the law. A person with possession of land is presumed to have a good title against the whole world, except someone who is able to prove a better title. That is in the case of Ruta or Fair versus Dankwa. The court, quoting from an earlier case, held that there can be no doubt whatever that mere possession is sufficient against a person invading that possession without himself having any title whatsoever, as a mere stranger. That is to say, it is sufficient as against a wrongdoer. The slightest amount of possession will be sufficient to entitle the person who is in possession or claim under those who have been or are in such possession to recover against a mere trespass. So the little possession that I have puts me in a better position to take any stranger home. Okay, unless the third party has proof of title to the land, right? Now title would be a lot of interest. So possession, documentation, combination of possession and documentation, oral tradition. Okay. Now possessory title. That means you being in physical or being a sort of physical control of a place. So possession title can only be brandished against another person who is unable to prove better title than him. So possession title, you can quote the case of Majolagbe versus Labi. Majolagbe versus Labi. We can also look at this one in team and others versus Boate. The court held that if a landowner who is also a farmer and as such well aware of local farming conditions, including the positions that cocoa when planted takes between 4 to 5 years to commence with, can allow his land to be occupied and develop unchallenged, such an owner cannot be allowed to recover possession and damage for the occupation and improvement of such land. The conduct of the landowner in such a case would amount to acquiescence. That means you look on unconcerned, but you don't like it, but you look on unconcerned, you don't take proactive measures. He stopped from claiming possession. Right? So that means he will be stopped from cancelling that promise or that promise being made. Okay. Now let's look at Mansa and another versus Asamoah in the case of abandonment. Okay. So the court upheld that whether stool land granted to a stranger had become untrobed or abandoned was a question of mixed facts in law. The land would be held to have been abandoned if either the stranger was intransigent or had effectively and voluntarily abandoned the land over a considerable period of years without any intention of returning to it, or had died intestate without a successor. The mere absence or death simpliciter of the stranger was not enough to constitute abandonment. There must be an intention to abandon, and the fact of abandonment must coexist with such intention, so concurrent. So in matter and another basis, as someone. Now let's look at legal equitable ownership of land. Okay, so that one is now let's go on. Conveyance or transfer of land. Okay, now sale of land. A sale can be described as a transfer of something entitled in return for money and or sale of value on terms agreed upon between buyer and seller. There are times when a land-owning vendor sells his land or portions of it for such valuable consideration. Sales of land usually come in two forms: customary sales and then sale under statutes. Now, these elements, let's look at the essential requirement of valid sale of land under the customary law. Performance of the land Guaha customer, a custom. That is, these elements were captured in K and Co versus Yadon II and Ano. Thus, in order to conclude a contract of sale of land in native customary law, certain customary ceremonies have to be performed before ownership in the land can be transferred to a purchaser. That custom is known as the Guaha custom. For personal property, the custom is 12 months. After the conclusion of negotiation, if the parties intend the ownership to pass from vendor to purchaser, they agree on a date on which the customary ceremony will be performed. They then invite witnesses for the purpose and proceed to the land. The representatives of each party collect some twigs and branches tree on the land and come before the witness. The parties face each other, the vendor holding one end and then the purchaser on the other end. They even declare the purpose of the ceremony. That the contract of the sale is now being finally concluded, and they break the tree in peace. After this, the witness receives witnesses and this concludes the ceremony. The Guaha ceremony, also known among the Akans, has its equivalent in the communities such as Sikatonyi, Bafu for the Kans, Ahatutu, Anyepa for the Ewes, and then Zipayi, Bapu for the Adandis. Now let's look at revocable and conditional gifts. Gifts once made are not revocable unless it was a gift from a parent to a child, or it was a conditional gift that is family kind of very close family kind of. John Mensa Saba remarked this in his book. Every gift when completed is irrevocable except in gifts between parent and child, which can be recalled or exchanged at any time by the parent in his or her lifetime, or by his will or by dying declaration. This is in case of Sese versus Sese and others, ORS, that's what it is. Now the plaintiff and the defendants were half brothers with the same father. Their father during his lifetime acquired a piece of land and built an outhouse on it. The father lived in the house with the defendant's mother, siblings, while renting a portion out, and so on and so forth. The plaintiff was allowed by his father to also build a 2-story building, and so on and so on and so forth. The father therefore made a customary gift of the land and the house and the outhouse to him, after which he said gift was evidence in writing. That bit of gift enabled plaintiffs to secure the needed bank loan and so on. Their father, however, continued to exercise his right over the house as the owner, collecting rent from them till his death. After his death, it was realized that he left behind a will in which he had gifted out the house to the defendant. The plaintiff, meanwhile, was demanding rent from the defendant, but the defendant resisted. Plaintiff therefore sued the defendant to recover the house. The court dismissed the case, holding that it was clear that it was not the intention of their father to gift the house to the plaintiff, and that even if that was his intention, he revoked the gift. In holding 2 of the head notes found a summary of the court's position on the gift. Now let's look at say on assessment in Kofi Taburu alias Nana Saben Diewu versus Madame Ajua Buaba alias Helena at the Court of Appeal stated that to ensure the sanity of custom, I think the law should frown upon a situation where a parent without just cause arbitrarily revoke a customary gift made to his son and for which he has accepted a ransom as such an attitude, if allowed and not checked, is likely to bring the entire concept of customary law gifts to disrepute and abuse. The position that a gift, when completed, is irrevocable except in cases between parent and child, which can be revoked by the parent at any time, should not be a general principle of customary law, as in some cases it would be unjust and unconscionable for a parent who made the said gift to revoke and benefit from it. Where a revocation of a gift by a parent to a child would mark fraud, the courts should not allow such a parent to perpetrate the fraud on the child. Wow. So it's not all instances that the father can revoke, unless if there's fraud in it. Okay, so let's look at Ata Kweku versus Kra and others. Features of customary pledge. Now, the plaintiff predecessors borrowed the sum of 300 cedis from a defendant, gave possession of his cocoa farm to the first and gave him the right to work on it and to take proceeds thereof for 7 years in repayment of the loan. It was, however, agreed that the plaintiff could refund the loan at any time within the 7 years, in which event the farm would be returned to him and the proceeds that in the course of the 7 years, the defendant, on the pretext that the debtor had broken the agreement, sold the farm to the plaintiff, who had meanwhile succeeded to the original debtor, brought his action in the court. The court found him guilty and he appealed. The appellate court upheld the appeal, holding that the pledge had no right to dispose of the pledge property while the pledge agreement was still subsisting. So if it is not completed, you cannot sell it. Once you give it away, it is still in the possession of the person that you have given it to. Okay, so we go on. So we have interest in land. Okay, there are so many interests. So individual groups, families to subs to clans, taking types of interest in land. You can have the allodial title, the common law of freehold, the customary law of freehold, usufructuary interest, leasehold interest, and then customary tenancy. Now the rights are registrable in relation to land under the following. The rights are mortgage, easement, restrictive covenant, profit, apprendum, power of attorney, a contractual license, a user of rights under a certificate of allocation. Now, the usufructuary interest coexists with the allodial title side by side. Now, usufruct, owner of the land, is here claiming an interest through someone already vested with the allodial title. In Ni Amun Kote versus Asres 2, the court acknowledged that the allodial title was vested in Asres 2, while the usufructuary interest was vested in the Ni Koi Olai family. In Ewa versus Edu Tutu and one other, the plaintiff acquired land from the Ankobians. He cultivated on a large portion of the land and gave out the remainder to another person to cultivate as an abomu tenant. The plaintiff sued the allodial owners for declaration of title and damage for trespass. The court acknowledged that there was an simultaneous coexistence of both the allodial interest of the stone as well as the usufructuary interest of the plaintiff in the piece of land given to them. The court stated that the plaintiff had an estate in the portion of the stone and of which he took effective possession, occupied and cultivated. The estate could variously be described as usufructuary, possessory, or determinable title. The usufructuary interest, the usufructuary title is a species of ownership coexistent and simultaneous with the two absolute ownership. This has nicely been put by Dr. Asante in his book Property Law and Social Goals in Ghana. At 53, the learned author said the stool, in effect, no longer has dominion of the stool land, but an interest in stool land conceptually is superior to that of the subject. A concept of split ownership is emerging, allowing the existence of separate by simultaneous estates in the respect of the same land. The usufructuary is regarded as the owner of the area of land reduced into his possession. He can alienate voluntarily to a fellow subject or involuntarily to a judgment creditor without the prior consent of the steward, especially if the person is coming from the area. If it's not coming from the area, then they have to notify the person. Right? So this can also be illustrated in Thompson versus Mensa. Now let's read the customary freehold versus vis-a-vis the common law of freehold. A freehold is an interest in land which is held for an indefinite period of time. Although in theory it is an interest which is held in perpetuity, in reality it is only potentially perpetual as it can be extinguished. There are two main types of freehold interest in land. These are the customary freehold and the common law freehold. These are separate interests which must not be confused with one another. These distinct interests in land, namely the customary freehold and the common law freehold, are captured, of course, in the other part of the section. Right, so to move on. Da Costa and others versus Ofori Transport Limited, and also in the case of Fuka versus Bosman, the court held that a deed of grant or other assurance of property takes effect immediately upon its execution by the grantor or assurer, and the property expressed to be assured pass at once to the grantee, although the latter has not executed or assented to the deed. In other words, once the grantor has signed the lease, for example, the terms of the lease are binding on the grantor and it can be executed against him even if the leasee has not signed his part of the lease. Okay, so that is supported also by Da Costa and others versus Ofori Transport Limited. So why a lease should be in writing. This is supporting why a lease should be in writing. Now the fact in Wells and then Lonsdale. So the defendant Lonsdale agreed to grant to the plaintiff Wells the lease of a mill for 7 years. The rent to be paid every quarter. A year's rent was to be payable in advance by the plaintiff if demanded by the defendant. The parties did not execute a deed for the lease, but the plaintiff moved in and paid rent quarterly in arrears. The defendant subsequently made a demand of the year's rent in advance. The plaintiff refused to pay because there had not been any formal creation of a lease as required under the common law. There was therefore no valid lease in existence between them, so it should be written. Okay. The Court of Appeal held for the defendant, insisting that the rules of equity should prevail. According to the court, going by the equitable maxim, equity looks on as done that which ought to be done. The parties were treated as having a lease enforceable in equity from the date that permits to grant the lease. Now let's look at the holding one, the Savage versus Give Up, termination by notice. The court stated no parties to a lease may expressly agree that, notwithstanding the fact that the lease has a definite date on which it would come to an end, any of the parties can terminate the lease by giving notice to that effect, and that can be supported by Savage and Give Up. The court stated a lease of tenancy for a fixed period could not be determined by notice unless this was expressly agreed upon. Now, so it should be open, everything. The length of notice required, the time when it should be given and all that. The lease, in the absence of such provisions, the lease would continue for the full period. Since the notice to quit was a unilateral act performed in the exercise of contractual right, it must conform strictly to the terms of the contract, and the onus of proving it valid lay upon the person by whom it was given. Let's look at the dissolution of company. Okay. What happens when a party to a lease is a company? Right, so of course a company is treated as entity. So limited only is one entity, so dies off. No one can sue. Denier of, so it's limited. Denier of title. Okay, so that is next question. Now building license. Okay, building license. Okay, if the land was given out for the building of a house free of charge, the licensee is entitled to remain in occupation of the land for as long as the building remains in existence. The moment the building falls into ruins, the gratuitous tenancy is also deemed to have come to an end automatically. This is in the case of Asset versus Anto in the Supreme Court stated, once permission of the ownership has been obtained to build a house or to farm on a family land, the house or farm remains the property of the licensee and his heirs and successors until the house is demolished or destroyed, when the land would revert to the owners. Now, sharing of revenue from stool lands, okay? So 10% revenue from stool lands shall be paid to the office of the administrator of stool lands to cover administrative expenses, 25% to stool through the traditional authority for the maintenance of the stool, 20 to the traditional authority, 55 to district assembly. Management of stool and skin lands, okay? Now, the Constitution defines stool land as a stool land includes any land or interest in or right over any land controlled by a stool or skin, the head of a particular community, so public, or the captain of a company. So in the olden days, captain of a company, for the benefit of the subjects of the stool or the members of that community or company. So public ownership kind of land is stool land or skin land. Now, legal features of stool or skin land. This can be supported by Kwam versus Yanka II. Now, a stool is a body corporate. This means that it has a legal personality. It can sue and be sued. Okay, so this is supported by Kwam and Yanka. The concession of a stool that it has already been accepted in the court of this colony is that it is an entity which never dies, an incorporation, so like that while the occupants of the stool may come and go, the stool goes on forever. So future people are also past owners, right? The accountability of the chief to his subjects. So Jemfim and another Owusu versus Owusu and others. The chief's immunity from his subjects, yes, that is according to Sabbath, okay, for his subjects. But to the prominent people, the elders, it is not so. Now let's look at the alienation of the stool lands, okay? In Akunsa versus Botry and J River Farm Limited, the Supreme Court held that stool lands are communally owned, and any alienation of such land by a chief without the consent and concurrence of the elders of the stool would render the alienation void. So void. You can also see Akwe versus Awulete. Now, the Supreme Court, in the payment of royalties to traditional authorities, okay, the Supreme Court held that it is the Republic, not the stool, that was entitled to any revenue or royalties, of course. But now, the state should be giving something for administrative work. It should be giving something for administrative work. That is also similar to royalty. types of families and the customary law in Ghana. Mills and Andy, the court explained that in the matrilineal area of Ghana, every woman who, being married, has children, originates a family. The family so originated is a branch of the wider family to which the originator belongs. The self-acquired property of such an originator, dying intestate, becomes the family property of her family, all which may be subject to prior life interest in the mother and the collateral of the deceased. Upon the failure of her family and the subfamily is created within it by her daughters and remoter family issues, the family in the female life. Their family property refers to the wider family of which the originator was a member. One's family property, always family property. Alright, so if you are building together as a group on the family property, you only enjoy it lifetime. If you die, it becomes family property. Now the patrilineal system, you can support it, similar one, that is Heyman and Atipo, Amuabema versus Oche. Oche is OKYIR. Okay, a family member who has been able to reduce a portion of the land into effective possession after acquiring some same through either actual or implied grant can maintain an action for possession against the head of the family. The family cannot therefore recover possession of the land from him unless he denied the family's title to the land. Okay, so that is supported by Heyman versus Atipo. Now let's look at Okwan and others versus Amankwai II. Okay, so this is under the definition of two land include family land. This two land is not equal to family land. That is supported by Okwan and others versus Amankwai II. Now we have a substantial contribution by the family. How privately acquired property could become family property if there's a substantial contribution by the family. This case can be seen in Labi versus Keto. Now, general principle governing the removal of the head of family. So the family members are to determine the grounds upon which they want to remove them. And of course, this should be some sort of formality with the prominent people around. Okay. Now, allote, this can be supported by allote and quote. The respondents who had been disposed as joint head of the Onamroko Ade family of Bese in Accra by a family meeting held on 21st July 1970, filed a writ on the High Court for declaration that he was still the joint head of the family and that he had not been constitutionally and customarily disposed. Now let's look at head of family accountability. Head of family is accountable despite the law to the contrary. A head of family or a family who is in possession or control or has custody of family property is accountable for the property to the family to which the property belongs. Tenancies, okay. So tenants, we have landlord and tenant relationship, or we have the customary tenancies, that is agricultural tenancies. Types of landlord and tenancy relationship, we have the periodic tenancy, tenancy at will, tenancy at sufferance, and then statutory tenancy. You should remember that if the landlord can interfere in your possession into embedded commerce, then that is more or less like a hostel, and that is not renting, it's different. And where you have full control of the place, then that is rent. Okay. Let's look at the recovery of possession of premises from a tenant. This can be seen in the case of Basel versus Esfarigilani or Sarkodie versus Karam and Sons Limited. Now, the mere fact that a tenancy agreement has come to an end is not by itself a ground for the recovery of possession of premises. In fact, any ground which is not found in either Act 2220 or not covered by common law would not be a valid ground for the ejectment of a tenant from a premises or recovery of sale. So you should remember that unless maybe for the person needs it for a necessity for himself or life demanding something for a near or very close relative. those relatives cannot recover it. You know, the landlord can also that will be a little debatable. Now let's look at the test of greater hardship. The test of greater hardship, the court is required to do balancing and looking at all the circumstances of the case to find out whether it is the landlord or the tenant who will suffer more hardship before making such order. Now the tenant will suffer more hardship, then the order should not be made. If on the other hand, it is the landlord who will suffer more hardship, then the order for the ejectment of the tenant can go ahead. So this can be seen in the case of Boatin versus June 4, the court remark. It should be mentioned in this connection that in considering the relative hardship, the court is not confined to weighing the effect upon the landlord and statutory tenant alone, but it should also consider all the relatives, dependents, lodgers, and so on, strangers within the gate likely to be affected, though the due regard to their status and their status and proximity to the landlord and the court should consider the extent to which hardship to them would be hardship to the party concerned. So that can also be seen in the case of Donko versus Chokoto. Who bears the burden of proving greater hardship? In the action of recovery of possession, the determination of comparative hardship between the landlord and the tenant was the question of fact for the trial judge, and his finding could not be disturbed if there was evidence supporting his conclusion. So this is seen in Donko versus Jokoto. Now, non-issuance of rent cards. It is compulsory for landlords to give rent cards. Okay, so rent cards, a landlord premises on monthly or short-term tenancy shall issue a tenant of premises within 7 days after the commencement of the tenancy a rent card specifying the name address of the tenant's premises, the amount recovered, and then any other prescribed particulars. Let's see priorities of instrument, or when does a registered instrument take effect? When does a registered instrument take effect? Registration to be actual notice. Okay, so now the provision in section 2281 of Act 1036 is however inapplicable to a judge's certificate or decision of the court. Now, sight must, however, not be lost of the fact that even though a registered instrument document would generally enjoy priority over unregistered documents on the land, the law would not come to the aid of the one who has registered the document if at the time that he acquired the land he was aware that the other party had already acquired the same piece of land. This is seen in the case of Amozu versus Oklika, right? Title registration. Now, the Land Act makes provision for the registration of titles to the land and related matters. Under the law, a person could register as a proprietor of the actual interest he owns in the land, and not just the registration of the instrument or the document. So the interests in land which are registrable under the Act are the allodial title, common law freehold, customary law freehold, usufructuary interest, leasehold interest, and customary tenancy. This is the agricultural one. Right? These are registrable. Okay. Now let's look at the importance of land title. Okay. Generally, once a person registers his title as a proprietor of the land and issued with a certificate, he acquired an indefeasible title. Indefeasible refers to the fact that it cannot be defeated. It's indefeasible. It cannot be defeated, annulled, or avoided. It has also been defined as that which cannot be altered or voided, usually in reference to an interest in real property.
I'm not lying.
So the testator or the one speaking must also
in Asante versus University of Ghana, the court quoting from Beaumont versus Eubank says that a donatio mortis causa is a singular form of gift. It may be said to be of an amphibious nature, being a gift which is neither entirely intervivus nor testamentary. It is an act intervivus by which the donee is to have the absolute title to the subject of the gift, not at once, but if the donor dies. So I can gift after my death. So you are waiting when I die before it becomes yours. So this can be supported in Asante versus University of Ghana. Mortgages. Now we are on mortgages. That's loan for housing.
Yeah, mortgages as loan for houses. Okay.
Foreclosure.
And the repayment is spread over a long period.
Forecloses a borrower's right of redemption of the mortgage property through a court order called a foreclosure order. The court will give a deadline by which the borrower can redeem the property by paying off the entire loan balance. So if you're not paying the loan, then I'm foreclosing and taking the house. But if you're able to do that, then you still have possession to thereafter. So thereafter, the lender is at liberty to sell the property, the one that you took loan to buy. The bank can take that property and sell it if you don't oblige within the time frame. So this can be found in the Kama versus Manza. Okay, the court stated that the mortgagor's legal estate in the reversion of the terms of years was not transferred to the mortgagee until the mortgagor had lost his right of redemption, foreclosure, or sale or other. Now, let's look at other portions of now, easement and then profit apprendo. So an easement refers to a non-possessory and non-ownership right that an owner of land or person with an interest in land exercises in adjoining piece of land. So you have your land, the land that is close to you, you have some degree of control, but not that you are the title holder. You have some degree of control, but not that you are the possessor or you are. It is for me. You are not claiming that it is for me, so you don't have. You are not claiming that it is for you, but you want to exercise some control. And sometimes you need to get formal ways to exercise that right. Okay, so let's look at the. Now, acquisition of easement, creation of easement. Okay, there are generally 4 ways through which easements are created.
Yeah. So just a point on the mortgagee and then mortgagor. The mortgager is the borrower, and then the mortgagee is the one lending, the lender. So here you see the change. Okay, so the party who gives the mortgage and receives the loan, the party who gives the mortgage and receives the loan, okay, the person is the mortgager, okay, is the borrower. And then the mortgagee is the party who receives the mortgage as a security interest and gives the loan, okay. So buying the house as a kind of a stand-in. Right, so that is it. Right. So there's the other point here.
This is express, that is opening, implied or prescription, and then the rule in Wilden versus Bowles. Wilden versus Bowles. Now let's look at Mabua versus J1. Okay, this is in case of marriage. Okay, that is spousal right in marital property. Okay. Now in Mabua versus J1, Justice Abou again stated that what the law calls marital property or spousal property is property acquired by a couple during the subsistence of their marriage. During the subsistence of their marriage. So when the marriage was in motion, whatever they are.
Yeah. So just the back to the point. So mortgager. So the mortgager, for instance, or the mortgagor, or the borrower, okay, as opposed to the mortgagee or the lender. This is very crucial so that you get the points out very well. So the borrower is the mortgager or the mortgagor, or the lender is the one who is the EE, the mortgagee, right? So we have the mortgager, and then we have the or the mortgage or the what we usually refer to as the lender as the mortgagee. The EE is the lender. That I think that can make it easier, right? So let's take notice of that. Let's go on with the rest of the notes. Yeah, so mortgagor, borrower, mortgagee, lender, right?
The wife could allow them as well to build. Now when a spouse acquires property solely before marriage, such property cannot be called marital property or spousal property. Stricto sensu, in strict sense. This was said by Justice Abou. Now let's look at implied agreement. In another case of Bechi Bedu versus Bechi Bedu, the wife petitioner and then the husband responded jointly acquired the matrimonial home. The wife purchased the land with her own resources, valued at 150 cities or so, and the husband erected the house, valued at so. After the marriage had been dissolved, the court held that the wife was the absolute owner of the house. This was based on the maxim, quid plantater solo sidet, meaning whosoever owns the land owns everything on it. Upon an appeal, the court held that the doctrine of quid plantater solo sidet is not applicable in matrimonial relationship, particularly in the acquisition of a matrimonial home. Alright, so that is in Bechi. Bechi is BERCHIE Bedu. Bechi Bedu versus Bechi Bedu. Now, Yabua versus Yabua too has a similar case. And then we also have the principle of advancement. Advancement is a common law legal principle that a person acquires property during his lifetime in the name of his next of kin. He intends to make an irrevocable gift to him. The principle of advancement has in fact been with us for some time. It is thus not a new principle at all. In relation to spouses, it looks at general legal effect of the acquisition of property by one spouse in the name of the other during the subsistence of the. So one gets it, all of them, and that can be seen in Quatsin versus Quatsin. Quatsin is Quatson versus Quatsin. Okay, And then in Ramia versus Ramia 2, you can look at that. Now the principle of substantial contribution, okay, in Quasin versus Quasin, the court appealed had relied upon the principle of substantial contribution to deny the wife a share in the acquisition of the marital property. It was this decision which was appealed against in the Supreme Court. The Supreme Court upheld the appeal. So it's a substantial principle does not happen in the matrimonial property. So there are situations, right, and there are situations in time will not run. Under certain circumstances, time will not run against a person vested with a right of action. Rather, there is a postponement or a suspension of running of the time. That's NRCD 54 makes provisions for situations under which the time would not run against a person who otherwise would have been vested with a course of action. These are disabilities from mistake, lack of knowledge on the part of the true landowner. Now, let's look at this one. Relationship between advancement and past. Ramia and versus Ramia. Okay, the principle of advancement is also where a husband purchases a property in the name of his wife. The law presumes that the husband intended to make a property to the wife unless either before or at the time of acquisition of the property he indicated a contrary intention. On the contrary, when a wife purchases a property in the name of the son, the law does not presume an advancement. In that situation, the resulting trust is created in favor of the wife against the husband. The husband would be deemed to be holding the property in trust for the wife. Wow. So this is a Ramia versus Ramia. So if it is a Burma, Neputwe, Oba can take until the person dies. Other than that, you're holding it in trust for the person. Now in Kwatin versus Amisa, the father had conveyed his interest in land to his daughter to enable her to use the document on the land to secure a loan. Upon this step, the daughter contended that the father had advanced the gift to her, has given the gift to her in advance. The court rejected that argument as evidence and showed that the father had no intention to give out the. Alright. So that is that for the law of immovable property of Ghana. Sorry, law of immovable property in Ghana.
Right. So we've gone through the sections. There is the whole. The collection of notes. Right. So for those in the primary section, what we do is we have what we call the drama, or the play tool, or also called the game. Right. So we make them listen to the narration, and then we have dramas and games, and then play like in the form of court issues, and then we see how they can through logic be able to analyze cases. Okay, so as they practice this, we see who wins, and that builds their confidence in debates and other things, and of course also prepares them. Remember, this is part of the mentorship program. Okay, so that is to prepare them. And one advantage is once they are exposed to these things, when they become adults, they happen to find themselves in the field of law. They already have had exposure. Almost every tenant, every corner of the law with respect to immovable property has been touched in this section. So they are already prepared. In fact, it will be a more or less like a revision for them. So primary, lower and upper, they have the play tool, or they have the game or the drama. The same thing for GHS, and then also for some SHS. Now for those in the tertiary, those in the profession, those adults, okay, this is more or less like a revision. It reinforces what you've already learned or what you are learning, okay, but it makes it more straightforward to them. We get to the point, okay, and then packages everything to how you need it. Remember, law, of course, comes with practice. Okay, the more you practice, the more you get to know it. You read around cases. So this exercise of the drama, the play tools, and then the games for the kids will be interesting for adults too, because when you listen, we usually will use cases. So we play the case, and then we give the set of rules, and then we allow the kids to use logic and then other reasoning abilities to decipher which direction the case goes. Of course, the same pattern of answering questions, the IRAC is followed, okay, but they are doing it more or less like a game, okay. So it's really interesting. And then we would also say that any parent who is interested, you can put some message in the comment section or send message, or you can call us. Our number is 0244 143032, 0244 143032, or you text. In fact, most would prefer text message, that your parent, your child is interested in the game or the drama for law. Then we will add their names to the list. Okay, they go through the registration. The other packages which ensures that they get into a very good environment for mentorship. That is, if they have the interest to become lawyers. If even they are not going to become lawyers, they get to know the law. It's going to help them in their various the various professions they will find themselves in. So this is the end of the discussion. So it's game for the kids, it's reality for the adults. Thank you very much.